Welcome back to the second half of our agenda today. And this second half will start off with navigating the ETF legal and compliance landscape. A lot of the most innovative ETF strategies globally have come about paying attention to legal and regulatory developments. And it's always a great idea to keep up with what's going on in that space. So Michael Prendergast, ETF Senior Product Specialist, Ultimus Fund Solutions, will now moderate. Thank you so much.
Thank you. Thanks, everyone, for joining us this afternoon. We have established a STEAM legal panel here to discuss past regulations, future regulations, and how it's going to impact the industry. As introduced, I'm Mike Prendergast. I'm the Senior Product Head, ETF Product Head at Ultimus Fund Solutions, where we offer full administration services and statutory distribution services for mutual funds and ETFs. We also sponsor 10 Series Trusts, which is a turnkey solution we offer clients to get into the ETF marketplace or the mutual fund marketplace. I'm going to kick it over to our panelists, going to have them do a quick introduction, and then we'll let the fun begin.
Great. Hi, I'm Morrison Warren. I chair our investment management practice at Chapman Cutler.
I'm Peter Shea. I'm a New York partner at K&L Gates and co-head of the ETF practice.
Hi, I'm Aisha Hunt. I'm General Counsel and Chief Strategy Officer at Defiance Analytics. We help ETF issuers and institutional asset managers raise assets through advanced digital marketing and distribution strategies. And I'm also working very closely with FM Investments on their ETF share class exemptive application.
And I'm Bibb Strench, a partner in the Thompson Hine office in Washington, D.C. And I always like to say at this conference, I was at the SEC when the application for the first ETF came in. And it wasn't spiders, it was super trusts. So for you ETF historians.
That's a good trade.
So kicking off, obviously, election's been top of mind with folks. And, given that, what's the current climate at the SEC? I'll just sort of can take it down the line here.
Wow. Yeah. It's to some degree, who knows what's going to happen. Obviously, there'll be a change in leadership. We've been dealing with a different SEC, one very aggressive in certain respects, created a lot of sort of animosity, I would say, even with registrants and participants. They were chastened to some degree with the Grayscale lawsuit, and so they were in an unusual place prior to the election. Now you could really see things changing seriously or materially. So my sense is, gosh, we'll have to see, but I'm assuming change is afoot.
Yeah, I think what we're seeing is that turnover, not just it's going to happen at the commissioner level, but there's a turnover going on the senior staff level as well. That being said, there's a number of rule proposals out. If any of them become finally adopted during what we call the lame duck session of the current administration, they would be subject to the next Congress's ability to rescind those rules. We're now in that window where if any rules are adopted by the SEC, they can be rescinded by Congress by a vote. And that's going to put a restraint on adoption of new rules for this current period. I think also the fact that you have senior staff at the relevant divisions of the commission are thinking about career opportunities, as it were, moving on. It's going to take. It would require new senior staff to spend the effort to finalize any rules that have currently been proposed. And frankly, when you have changes of administrations, even if it's within the same party, often the rule-making initiatives, since there's proposed rules out there lingering, they tend to get, pocket vetoed. Nothing happens. They just die on the vine. That's pretty ordinary course. I'd expect that to be the case here. I think there are going to be, we'll get into it further discussions in our panel discussion here about other initiatives, but there's certain things that I think the commission does have an appetite, institutional appetite to do. Like we'll talk about regulation of AI, use of AI in the financial services industry. We'll talk about potentially oversight of service providers by registered investment advisors and things like that. There's a variety of things that institutionally the commission will be revisiting just because they think it's clearly within their ambit to do it. The question is, what does the rulemaking look like? I mean, we can get into a little bit about what they've done with AI, and there was a rule proposal outstanding, but the commission came back and said we need to repropose it anyway. So we'll see. We'll see. I think Bib can talk further to it, but it's going to say there's definitely change is going to occur at the tone of the top of the commission. The way the chairman's office has dominated the commission for the last 4 years, basically, it's going to change. And it's going to change how rulemaking occurs, and it's going to change how enforcement occurs. And the current administration coming in is deregulatory. That's going to have a distinct flavor, and there could be budget cuts to the enforcement program. We'll see. It's all this is up in the air right now.
I think we're entering a very innovative era. I think the new commission, or we know that Gensler is likely to be replaced, and with that will come, I think the ability to bring innovative product initiatives to market much more efficiently, and I think we'll see, a focus on supporting products in the digital crypto space. That's obviously a priority of the incoming administration, and there are folks joining, I know in these transition teams that are very focused on supporting, innovative initiatives in that space. And I agree that there will be a rollback of the current enforcement agenda, including enforcement related to off-channel communications. There have been, a series of fines, as everyone's aware of. So I think there will be, less focus on enforcement and more focus on supporting innovative product development initiatives.
Yeah, I mean, you would hope there would be what I think normalization, and it really goes back, like I said, to when I was there and then the years after. And I think a great example is, is a new ETF and a new product. Normally how it used to work is you filed it, you got comments from the staff, they were on a deadline, a 75-day deadline. And, this is obviously important to a lot of people in the room because getting ETFs launched is critical. And then you had the choice. You could take their comments and change your disclosure or not. And it rarely percolated up to the branch chief, so you're way at the bottom. There was no such thing as a BXT. Really, with Gensler and everything coming down from the top to the bottom, they imposed a lot more control. They introduced, to me, a concept called a BXT, where they would ignore a rule that said that they had to, allow a new fund to go effective within 75 days of the filing, and now they could, once they had that, they could literally dictate the disclosure, especially obviously with the names rule and anything with Bitcoin. So, in a hopeful world, things would return to normal. But then you have the higher level of, what is going to happen with the new administration and the new chairman. And now the precedent has been set that the chairman can control the staff. They don't delegate like they did in the past. So there's a high level of unpredictability, which, is never good for an industry.
Okay. As we look to sort of, new product type, I mean, the ETF share class is out there. Obviously, when we met 6 months ago, there were 12 applications. We're up to 34 plus, and there's some variations of that filing out there. What are some of the sort of the concerns the SEC has with, overall with the structure of some of the applications?
Yeah, I think the basic concern is that you will have cross-subsidization. So you'll benefit one class for the other. And that has been expressed throughout the entire process. Now, clearly, Vanguard has exemptive relief they've used for 20 plus years. I think they have over $1 trillion in that system. And so it's something that functions at least well enough not to collapse. And that's probably one of the stronger arguments to allow for others to do it. There are potential solves for that. They've also mentioned cash drag as being a potential issue because a mutual fund has to meet redemptions and ETF doesn't in the same way. They've mentioned perhaps losing some of the benefit of the tax-free nature of ETFs, even though that's not a 40 Act driven benefit. But they're thinking perhaps mutual fund redemptions may interfere. Swing pricing was thrown out as an uncertainty, but I think that's been eliminated. But the general gist was, and we were associated with the very first filing, was they just didn't like it, right? They didn't want to move forward, and that's sort of the issue that I think that there's a weakness here, especially post grayscale. Just not liking it isn't an argument to having an unequal and an arbitrary system for making determination. So I imagine all of us are at some level expecting that relief's going to be granted, just a matter of when and what the conditions are. But that's my sense as to their issues.
So Aisha, is there any evidence that the SEC is actually actively engaging this? So we've seen a lot of filings, but not necessarily. We don't know if there's been a lot of feedback.
Yeah, I can attest to they're certainly engaged and very active. In fact, we're meeting with them next week to discuss, our application. FM Investments was the third applicant to file. Everyone's familiar with Perpetual withdrawing their application due to commercial reasons, and Dimensional still, first in line technically. However, we believe that we're really at the forefront of this because we have, really strong facts and circumstances that the SEC has been very receptive to discussing with us as we focus on single treasury ETFs, particularly T-bill, which is holding a 3-month T-bill. And so it, inherently addresses some of the cross-subsidization concerns that Morrison mentioned around cash drag because it's holding cash equivalent. So there's no need to there's no problem in terms of meeting mutual fund share class redemptions. So we're seeing traction. I think the challenge is that this is we're uncertain, and I think the one through line through all of our thoughts will be we're uncertain, and there's a lot of unpredictability in terms of the staff composition, and so we're uncertain, whether or not we'll be continuing this discussion with some aspect of the same staff, or if this will be a completely different staff. But either way, I think to Morrison's point, we certainly will see ETF share class relief. I think that will happen in 2025. I think FM might be able to obtain relief sooner than some of the other issuers, given the facts and circumstances. But overall, I think the broader relief will be provided in 2025, given the business-friendly likely tenor of the new administration.
Yeah, and I think it's important to point out, these are exemptive applications, so they're one at a time, or they can do a group. They're not a rule, so it's not like if it's granted, all of a sudden the whole industry is going to be able to take advantage of it. So I think what adds to the uncertainty is who's going to be the next SEC chair and the commissioners, and if the staff wants to get this out before that happens, there could be a rule proposal shortly thereafter, and maybe it waters down some of the conditions that the staff is insisting on.
Yeah, I think basically there's been no political capital or political will to spend political capital at the commission for ever since this Vanguard patent expired 2 years ago. And so the staff is keenly aware that they've granted Vanguard a competitive advantage. They abhor that. They don't like it. But then again, they have these fairness issues. Bib, you'll appreciate it. You'll appreciate it more. That the staff always reserves the right to get smarter. So they looked at the rationale underlying the Vanguard application, and they said, well, actually, we see other issues. So this is where the subsidization between the share classes, this is where fairness issues have entered into it. But at a certain point in time, a lot of the solutions that offered up resolved towards giving the board, independent trustees and the board, the authority to resolve these potential issues, these potential cross-subsidization issues, to monitor them and account for them and make sure that they're giving the investors of all share classes a fair shake. I mean, that's kind of where a lot of the applications have landed on what, using the current governance structure to oversee these potential issues and creating safeguards in that regard. So there is a way around a lot of the staff's concerns, but no one's been willing at the staff level to say, okay, we're going to allow it now, because they can't do it without Chairman Gensler to say so. Chairman Gensler just wants nothing new. It's not on his agenda. There were statements made when the first single stock ETFs were approved that the ETF rule was a mistake because it gave up the ability of the SEC to control the industry on an ad hoc basis. So that's kind of where we are now. This is changing. I would agree with Alicia that we're going to have in 2025, we're going to have some headway on this, I believe.
Yeah, absolutely. I think that just product development initiatives are going to change also due to, I think, a broader demographic of very innovative folks from the technology sector moving forward product development initiatives and having a different standard in terms of patience with the typical regulatory process. And I think in light of the grayscale precedent, you may see more aggressive tactics of that nature utilized to move forward innovative product development initiatives. I think we'll see, next year 3X products. I think this is going to be a different era in terms of innovation, and I think the focus is going to be really on, how do you support the industry from a practical and in an efficient manner.
Anybody care to handicap when we think we might see some sort of approval?
I think Aisha's thinking 25. I'm a little more skeptical just because of the transition and the time it takes to actually get things done. And there's 34 applications are different. Wrestling with them, it may be easy to pick off one easy one, and so that 2025 might be possible for that. In a broader sense, it just seems like it pushes, to 2026. But this is just guessing. If you have a hyper motivated driver, someone who takes this as their project, maybe 2025.
And coming from the operation side of things, there is an operational component of this from an industry standpoint to make sure that we have automation around the process, especially around the ability to, transfer between share classes with the various systems. So, there is a operational component that the industry will figure it out once we get good guidance on which way we're going.
Hey, we did T+1.
Okay.
So the industry figures it out.
Right. We always do.
Yeah, one of the things, and I agree with you, Morrison, that I think the FM application is so unique, right? Because it's again holding this 3-month T-bill, and it's also an existing ETF that's trading on an exchange, right? And so to be able to add a mutual fund share class, there's certainly room to discuss how to address operational issues differently in some of the other applications. And so we believe that will help pave the way for broader relief. But certainly for products like T-bill, we do think that relief will be obtained in 2025.
Some of it's like going down a rabbit hole with the staff on these discussions of these applications. And I'll be brief. One recent thing came up about a month ago or so, maybe a little bit longer ago. It was the staff asking, what happens if the mutual fund class declares a dividend on a different date than the ETF share class? How do you make that fair? And it's like, I'm mystified. It's like, why can't the board decide what dividend dates they're going to approve for what share class? What does it matter? And for some reason they're looking for where everything can go wrong all the time. This is what I'm talking about. Political will requires someone at the senior level of the commission to step in and tell the staff, this must be done now. And they'll take the heat.
I used to be in that office, and I was just out of law school, so it's great. You could just keep asking questions after questions. But eventually, shows how old I am, we had just gotten computers there. So the division director is like, why has this application been in there, 42 days, which is nothing these days. So, it will take somebody from the top if we're going to shorten the time frame.
So, sort of moving forward, we've seen recently cases coming out, whether it be Grayscale, Chevron, you got Loper Bright, and you got Juraski. What is that with that backdrop? How's that impacting rulemaking, any potentially enforcement on new product approvals?
I think that there's going to be an uptick in utilizing Loper-Bright, which overturned Chevron and no longer provides the regulatory agencies, including the SEC, don't have the same deference that they had pre-Loper-Bright. And I think there will be an uptick in terms of considering that as a strategy, considering a litigation strategy to be able to move forward innovative product initiatives. And again, I think we're going to be looking at, folks from the technology community that operate, are used to, pushing through what they'd like to push through. I mean, that same community gave us, the grayscale precedent. And I think that there's going to be continued consideration of litigation strategies to move forward product initiatives. And I think Loper-Bright is a path along with grayscale to getting there.
Yeah, I mean, one thing I think the SEC lost sight of is that you can't, as a regulatory agency, just adopt any rule. It needs to be grounded in a statute. And besides those cases, they lost or got stayed a couple of circuit court decisions with an overly aggressive hedge fund rule where there was no statutory basis for it. And likewise, with the ESG rule, making the necessary findings to support that rulemaking. So I think, and given the cases Alicia and others have talked about, I think there's going to be a more thoughtful approach to rulemaking. It used to emanate out of exemptive applications, which is what I'm talking about with the share class release, that once they did 5 or 6, 10, 12 applications, then a rule would follow. Now they're concocting these rules kind of out of thin air to advance some kind of agenda, and I would expect that behavior would be chilled a bit.
I would just add on the enforcement piece. It's interesting because there are certain regional offices that may give us, a bit of a tea leaf in terms of what we can anticipate with this, new administration. So if you take the Atlanta regional office, it is far less active on the enforcement front. And so it's markedly, different than what you see in a lot of other regional offices. And that could give us some insight into, at least what's likely to occur from an enforcement perspective.
I would be interested to hear from the other panelists, but since I've gotten over, and all of us have been practicing a long time, there was a certain deference that the SEC had that starts to be lost when they're giving pronouncements not based upon statutory or rule parameters, and that's happened, and so therefore there is an aggressiveness and a willingness to push back on the staff that's very different. I mean, how many no action letters do you see get filed at this point? There's, folks are making determinations and moving forward, and when it relates to disclosure issues or new products, they're taking advantage of rules that allow for them to be automatically effective and being very aggressive and pressing the staff into positions and really challenging those positions that seem not to be grounded in the rules or statutes. So that environment seems to be accelerating, and then these cases they're losing is not helping. So it'll be an interesting time.
Yeah, I don't think Chevron impacted the SEC much because the courts are very willing to get rid of their rules on other grounds. Especially cost-benefit analysis under the Administrative Procedures Act, the courts are very willing to strike down a host of SEC regulations over the years. I think what it's going to impact is future rulemaking is going to have to be, I think we're going to say it's going to be a much tighter process. It's going to force the commission to really, as we've been discussing, ground the rulemaking in the original statutes that define the commission's authority. And there's going to be less and less latitude to issue interpretive guidance. I think you're going to see a lot of restraint on that. And I think, Alicia, your point's well taken about the enforcement program. It's quite possible, who knows, the next Congress could slash the enforcement division's funding in half. We've seen that before happen with the change from a Democrat to Republican administrations, that the enforcement program is essentially, it has to be egregious fraud. It can't be a money-making operation. Like this off-channel communications thing that gets registered investment advisors and broker-dealers turned into a cash cow for the Treasury through the SEC. And it's sort of like, well, they could have handled that. I think your point more so is they could have handled that a much different way through sort of like industry alert kind of things. Like, if you stop this texting, or we're going to come after you. But no, they just went after everybody and started making money off of everyone. So we'll see.
And you do wonder, I mean, all the fines to all these firms for this same practice that, and we were talking about this before we came on, when they could have just said, stop it now, today. And if we see any more of this using multiple devices and not maintaining records, then we're going to punish you for it. Versus
make a referral to DOJ,
right?
A criminal referral,
right? So it's the sense you get is there is sort of at times a real skepticism at the staff regarding the participants that is led to a circumstance where you're really not sure what will happen in any given environment. So that really could use being sort of rejiggered and reoriented so that there's a more positive environment.
I think there's going to be some disruption as well. I think, looking at prior Republican administrations provides us with some data points about how this administration can move forward. But I think that there's going to be generational sea change. I think there's been a lot of innovation that's been chomping at the bit, especially under a Gensler administration, that will be unleashed on, the SEC. And I think they'll be using more aggressive tactics that do leverage Grayscale, Chevron, and other cases that they've alluded to, and so I think we're in for no one knows for certain what's going to happen, and it's a space, it's a regulatory space, it's ripe for disruption and innovation, and that's really been in some ways stifled quite a bit by Gensler, and I think I think the newer direction is going to be a different chapter of the SEC that we haven't seen before.
And speaking of innovation, how is AI tying in, or how's that going to impact filing going forward?
First of all, there was a rule proposal about use of AI by broker-dealers and investment advisors. And I think it will impact going forward. I mean, it's a rule proposal. The commission came out and said, let's repropose it because we got so many good comments from the industry. There were a lot of problems with the proposed rules. But I think there's a couple of themes that will guide the commission going forward with AI. One is that there's a potential for embedding conflicts of interest where the interests of the advisor or the broker-dealer for generating fees or whatever it may be is at odds with the investors' interests. And so they're going to have to come up with a regime where that's dealt with. The prior proposal was pretty rules-bound. It was pretty proscriptive. It wasn't principles-based. And we're hoping that maybe we get more of a principles-based project coming out of the commission regarding AI use. And part of the problem was that, for instance, the broker-dealers, the investors was an ordinary human being, right? An investor was a natural person. For registered investment advisory firms, an investor was any client. So it could be a corporation or whatever. So there was a disjuncture that made a real headache for firms that were both broker-dealers and RIA firms. And so there's a whole bunch of issues that came up with the rule proposal. I think it'll continue going on. AI will be something that we're going to be living with going on forever. And the commission's trying to get ahead of it. The first shot was kind of a misfire. It's going to happen. I don't care what regime you have. I don't think we can have a new type of activity where people can stand back and say, oh, it wasn't us doing it. It was our AI that did it. Well, it's like you operate the AI, so there has to be some ownership taken of it by these firms. And this is a matter of how do we enforce that, I think.
And I would think that the rulemaking agenda would be informed also by, this mandate to eliminate efficiencies. And I think it'll be interesting how the SEC itself uses AI, right? To what extent do regulatory agencies, incorporate more efficient processes that leverage AI, and as they use AI and younger generations are using AI at the SEC, how does that inform their rulemaking around AI? So I think AI is becoming very commonplace. in a lot of industries, and it's only going to accelerate. And I think, given the mandate to eliminate inefficiencies, that AI is certainly a way to do that at the SEC.
Yeah, I just don't want to hear my portfolio is hallucinating.
Well, don't invest in certain types of stocks.
But, I think their approach right now with AIs is a classic example by regulation by enforcement as well. So I mean, they basically, it seems like they've tried to kind of chill the use by bringing cases or threatening to bring cases, saying that how the advisor is using AI is not adequately disclosed, and that's a very subjective thing. And you always lose, with the SEC. Their subjective analysis trumps yours.
Yeah, it's up to the 2 enforcement cases this year, or called, for lack of a better term, they're AI washing. You hear the greenwashing cases. This is AI washing by investment advisors.
So, you're looking at that. I mean, a couple of things that are out there. I mean, now it's sort of comments on where do we think they're going to go. So the impact of the names rule. And the other thing would be the oversight rule. Do we think they're going to survive? Are they currently there and have to be dealt with? Do you think there might be adjustments to it going forward?
We could spend the entire rest of the time talking about the names rule, but I don't want to do that. So
we give you 2 minutes.
Okay, 2 minutes. Just names rule. It's the 80% test. They're expanding. It is already adopted. It's been amended. This 2001 rule was amended last year. The compliance dates are for large funds, families of funds over $1 billion of AUM. It's basically December 11th, 2025. Smaller funds, it's June 11th, 2026. These are the compliance dates. What my clients are encountering is that it's a lot of work. Now we're looking at things in the terms used in names of funds. We have to put an 80% test on the portfolio if the name suggests a particular investment focus, has a particular characteristic of investment. And so you get to the portfolio management will have to define the terms that are identified as implicated by the rule. Portfolio management will have to provide written documentation at the time of investment of why the security selected for investment meets the definition of the 80% test. They're going to have to test it periodically. The SEC says every quarter end you do it, and you get 90 days to cure a problem. The thing is, some portfolio strategies may require more frequent examination of the stocks in the portfolio or the bonds or whatever it is to make sure it meets the 80% test. And there's some hard calls here. And people have to realize that when you adopt, there are FAQs, frequently asked questions, issued in 2001. Some of those will survive. Some of those are going to go away. Some of them are obsolete. The staff is reportedly on the cusp of issuing new FAQs for this new rule. So we're hopeful we get some good guidance. The problem is if you have an existing 80% test and you have to adopt new tests for these new terms in your fund's names, you have to figure out whether or not you have to give us, is it a fundamental policy or is it non-fundamental policy? If it's fundamental, you have to get a shareholder vote to change it. This new rule could cause you to have a proxy solicitation if you have fundamental policies and you're changing them. If it's non-fundamental, you have to give 60 days advance notice to your investors that you're changing the policy. So the compliance dates are not, in fact, December 11 and June 11. They're 60 days before then. You have to get this in place so that you're in compliance at that date. So there's a bunch of groundwork that's being done now. CCOs and general counsels, a lot of fund sponsors are going berserk over this stuff right now, especially if you got hundreds of funds.
It has been, there's this, I guess, an assumption that the name is so important that you have to go through this very involved process now that's been evolving over the years. And there has been a names rule for a long time. But the rule was really focused on really key terms that could drive someone's investment. And it's been expanding. Staff was running into barriers because they were trying to expand the rule without an underlying rule to do so. So there was the ability to push back, and so we're here now. I imagine we're going to have to live with this, and just it is what it is, and there's still a lot of interpretation to happen. So I think we're going to live with this. The outsourcing due diligence rule that as proposed, I'm assuming that that could be watered down because it's very difficult, and ultimately assigning responsibility to an advisor for a third party who provides a service at a given rate that may not motivate them to act in a given way or assume liability or responsibility. It's a very difficult proposal and would be quite onerous. I think what's happened with, there's obviously a need for compliance. It's important for protection of investors and assets, but what it's done is it made it very difficult for the smaller providers to continue to function, especially in a world where now mainly ETFs are unitary fee products that you're capped in terms of what comes in the door despite your compliance obligation. And so, hopefully there's some rationality as to what's necessary versus what may be optimal for the biggest shops to do, so that the smaller providers have a chance to compete.
Yeah, because the way the rule, when it becomes effective, is that you'll almost have to react real time to some of the portfolio positions, and you'll have to loop in your portfolio manager, and you'll have to, if you're using an outsourced compliance provider, loop them in. And as Morrison says, all these are costs, and the industry, especially the small and mid-size, have already been dealing with liquidity rules, various reporting rules, and it's leading to make it less economical to be able to offer an ETF. At the same time, there's hopeful that they're going to free the reins and allow more innovation in the industry, but it's going to be cost prohibitive to even launch an ETF going this direction.
Sort of moving on and looking at sort of recent filings. I mean, we've seen an increased filings of folks looking to put either private placement, their liquid assets, private equity into their ETFs. What are some of the concerns the regulatory bodies have, and what are some of the constraints they're operating under?
Well, I mean, an ETF is at its core a mutual fund and has to meet redemptions. And so therefore, a limited number, 15% of its assets can be illiquid assets. And so you have that fundamental need to meet redemptions to allow for the arbitrage mechanism to work for ETFs. And so when you're bringing in other asset classes you that are less liquid, you would have to be able to assure the ability to sell those assets at a price that's close to where they're priced. And so that's the real challenge. And some of the proposals out there is, well, you would provide a liquidity source. Well, is one source enough? Does that source have to basically buy the assets at the price they're priced at, or can they price them at any price, right? Those are the things I think that you'll have to settle on before you can put assets that are essentially illiquid into a liquid vehicle. But I will say, when you look at senior loans, when you look at emerging market debt, when you look at there are asset classes, when you open them up to being offered in an ETF, they've traded well, it's worked. But liquidity has been there for those assets. So the challenge will be, will there be adequate liquidity sources? If so, then arguably you'll get there.
Yeah, and this may be an example of stressing the ETF product, as you're pushing down these directions. So I mentioned I was there with the first application, and the issue, and it was more market reg, which is what it was called then, was the NAV per share and the share price, and having a mechanism to drive those closer, and that's the cornerstone. And as you're introducing more private equity strategy, hedge fund strategies, and you're stressing out that core function, and there's really there's no self-policing. I mean, I think at the end of the day, you hate to even want to think about this, but the industry has managed to have ETF products that have worked. There's no policing in the industry that if an ETF product had a problem, much like the money market fund did. Do we want to stress too much? Don't forget about kind of the golden goose here. But there's lots of pressures to put more and more things in the ETF structure.
Just real quick, I've known that I've heard senior staffers in Division of Investment Management tell me basically they're absolutely opposed to the retailization of hedge funds. They're against retailization of private equity. They think they're much more sophisticated products that the retail public ought not to be allowed to invest in, literally. So, if you can get over the tax regulations that require, all good income coming from securities, if you get over the 15% illiquid securities issue for open-end funds like ETFs are, you're still going to run into this headwind where the staff just is very skeptical of this kind of a product for a retail investor. And that's something we've overcome in the past. There are hedge fund replicator ETFs out there today trading, but it was a long time and a big battle to get through the SEC to get it done. So I'm hopeful something can get done.
Sure.
But you've always had the gate, with hedge funds that they're limited to certain classes of investors, and you don't have that gate obviously with the retail. So there's always that tension.
I think we might also see, unpredictable kind of rulemaking, right? There could be a more aggressive demographic of ETF issuers and fund managers that will be utilizing, lobbying efforts that we haven't seen previously. I mean, we previously kind of centralized a lot of lobbying efforts around, ICI organizations of that nature. And so what do the lobbying efforts look like going forward? And what, areas of our economy will be lobbying to leverage the wrapper, the ETF wrapper, to get access to retail distribution. And we've had SEC commissions that have done rulemaking and have created unintended consequences. So I don't think we can just predict that the SEC will continue to make the assumptions that are kind of baked into current rulemaking. I think that there'll be some really pressure brought to bear on the SEC to think about rulemaking very differently and potentially roll back some of the rulemaking that's been made, some of which could help mitigate risk for certain product types, and the industry may have to deal with just the unintended consequences of rulemaking in a way that is a little bit more akin to the Wild Wild West and giving entrepreneurial opportunities, a regulatory landscape to really explore what's possible using the ETF wrapper.
Yeah.
I guess one additional thing I want to say, are they merit regulator, right? Is that their task, right? What are they assigned to do? In certain circumstances with ETFs at this point, if you satisfy the various rules, it's 6C11, the listing requirements, and you go through and register your products as you're supposed to, you can sell essentially anything that fits, right? And they're supposed to step out of the way. They don't like that. Right, and so and that tension, like there's a question: do they have the power not to like that? They do have the ability, and FINRA does as well, to interfere with products getting into the hands of investors through regulated parties, like through broker dealers. And the complex product discussion is one circumstance, but that's a fairly broken system too, right? It is, when you start to try to limit the ability or limit products to various people, it is just hard to do in any way other than a case-by-case circumstance. And so we're running into that. And crypto is obviously something they didn't like. The complex product designation is slapped onto anything with derivatives, whether derivatives help you reduce risk or not. These are systems that hopefully they work through by understanding, stepping into this role of merit regulator is, it has consequences that aren't necessarily good.
I mean, to an extent, we could have an agency that acts like the Toronto Stock Exchange, right? The Ontario regulators, where basically, they analyze the product, they realize it's viable, but they really can't say whether it's good or bad. They just let it go on the Toronto, start trading, and if it fails, it fails. People get their money, whatever the value that it was designed to offer. If it's bad value, so what? It goes away. Big spreads, it fails. Good, go away. I think instructive is knowing what happened in 2008, 2009 financial crisis, leveraged inverse ETFs in the financial sector, bank sector, really didn't perform the way investors thought they would, because there were compound returns over days as opposed to like people were holding it for months, and they had completely the worst investor experience. They lost money and they got taxed on income gains. But anyway, you had the division head, Buddy Donahue's in front of Congress, and as an Alabama Congress critter, yelling at him saying, "You're the worst regulator I've ever met in my life." And so basically that is sort of like what the agency faces from the Hill when something goes wrong. So the institutional inclination is to be very conservative in allowing new products out.
Yeah.
So this is the political capital issue.
Sure. Just got 5 minutes or so. I'll just throw it out real quick for see if anyone has any questions. Much.
Thanks, Steve. Question for anyone and everyone who wants to weigh into this. So think in the next 18 months, what are you most optimistic of getting past? That's so optimistic, realistic in the next 18 months that's going to benefit everybody in this room. And then optimistic, not so realistic, but would be really nice if that could get passed in the next 18 months. So 2 different buckets.
I think really nice would be ETF share class relief, because you'd be providing ETF issuers with access to 401k distribution platforms. To be able to raise assets through the 401k platforms is a significant boon to the ETF industry. And I also think with rapidly growing Gen Z generation looking for more innovative product options in their 401k plans to speculate on exposure to certain more exotic asset classes, it's ripe. The demand is ripe for it. And there could be even some pull demand, because folks would like to put their retirement assets to work through their 401k plans to get exposure to some more exotic asset classes. So I think it's a win-win for investors, and it's a win-win for the ETF industry and the mutual fund industry as well.
Multi-share class has a chance in 18 months, right? And I think that'd be helpful. It'd be nice if we could sort out complex products, because now very sophisticated products that are designed to give regular people exposure to investment strategies that that institutions have that allow to mitigate risk. That's something it'd be nice if that would be available. I would love if we could get away from our need to generate paper. We've gone backwards of late, requiring shareholder reports in paper versus electronic. That to me seems to paper should be an option, but electronic, obviously is efficient and can be used well. Obviously with crypto, we need to sort something out. Folks are investing in crypto. They're investing in crypto in ways that are much less regulated than they could be, much fewer protections. And so it'd be nice if there were some guideposts that allowed for investing in other than just Bitcoin and Ether.
I'm hopeful a solution of proxies. Obtaining a vote is tremendously expensive, and using whatever technology, blockchain or whatever, to solve that, that would be hopeful in 15 months or so. What's not going to happen, what I would love, and most of you probably don't care, is that our disclosure document, we have a summary prospectus, we have a statutory prospectus, and we have a statement of additional information. What is that all about? Can we have one document, and can it just rest on a website?
Yeah, boy, hopeful. You hope that the commission evaluates market makers' relationships to their business model, to what they do for the ETF industry, is maintaining narrow bid-ask spreads. And what we're seeing is the commission under Reg NMS is reducing, yet again, the compensation for market-making firms to the point where they aren't making enough money off the trades to share that money with people who are giving them order flow. So payment for order flow is going to be impaired, and that's going to impair market making activities. And we are about to enter an experiment in the ETF industry on bid-ask spreads because of the change in market maker compensation. So it's going to be, my hope is that basically the commission's, yes, reducing costs to the end investor is very important, but also stable markets and well-functioning markets is also a policy goal. So I'm hoping that gets more of a look than what the current regime has given it. That, I think, definitely in the next 18 months we will see ETF share classes. It's an idea that's too good to stop.
Right. Well, I think that's all the time we have. I appreciate everyone attending, and thanks to our panelists.